Hello, friends. Welcome to my YouTube channel. I advocate Jain Pandey. Welcome you. Today we will discuss about compassionate appointment. That is, on which ground a person can apply for the compassionate appointment in government jobs. Compassionate appointment is governed by recruitment of dependents of government servants dying in Harness Rule 1974. So, the most important part of this rule is Rule 5. What does Rule 5 says? Rule 5 says that the recruitment of a member of the family of the deceased, in case a government servant dies in harness after the commencement of this rule and the spouse of the deceased government servant is not already employed under the central government or a state government or a corporation owned or controlled by the central government or a state government, one member of his family who is not already employed under the central government or a state government or a corporation owned or controlled by the central government or a state government shall, on making an application for the purposes, be given a suitable employment in government service on a post except the post which is within the purview of the Uttar Pradesh Public Service Commission in relaxation of the normal recruitments rule if such person fulfill the educational qualification prescribed for the post, is otherwise qualified for the government service, and makes the application for the employment within 5 years from the date of the death of the government servant. So this clause is very important. The person who is applying for the compassionate appointment must apply the application for the employment within 5 years from the date of the death of the government servant. Now there is some exception for this, that provided that where the state government is satisfied that the time limit fixed for the making the application for employment clause undue hardship in any particular case, it may dispense with or relax the recruitment as it may consider necessary for dealing with the case in a just and equitable manner. Now we will see what the Honorable Supreme Court says about the compassionate appointment in various judgments. So, in the case of Sanjay Kumar versus the state of Bihar and others, the Supreme Court observed that this court has held in a number of cases that compassionate appointment is intended to enable the family of the deceased employee to tide over sudden crisis resulting due to death of the bread earner who had left the family in penury and without any means of livelihood. On the date when the first application was made by the petitioner was a minor and was not eligible for appointment. This conceded by the petitioner. There cannot be reservation of a vacancy till such time as the petitioner become a major after number of years, unless there are some specific provision. The very basis of compassionate appointment is to see that family get immediate relief. Now in another case, Union of India and others versus Srimati Asa Mishra, the Supreme Court says the principle was formulated in the following observation. The principles of consideration for compassionate appointment have been firmly settled and have been reiterated from time to time. Compassionate appointment is not a vested right or an alternate mode of employment. It has to be considered and granted under the relevant rules. The object of compassionate appointment is to tide over an immediate financial crisis It is not a heritable right to be considered after an unreasonable period, for the vacancies cannot be held up for long, and appointment should not be ordinarily await the attainment of majority. Where the family has survived for long, its circumstances must be seen before the competent authority may consider such appointment. It is not to be ordinarily granted where a person died close to his retirement. Now we will see there are certain principle which has been set up in the case of Shiv Kumar Dubey and others versus state of UP. The full bench judgment. What does it says? It says that in para number 29 it says we now proceed to formulate the principles which must govern compassionate appointment in pursuance of tying in harness rule. A provision for compassionate appointment is an exception to the principle that there must be equality of opportunity in matter of public employment. The exception to be constitutionally valid has to be carefully structured and implemented in order to confine compassionate appointment to only those situations which subserve the basic object purpose which is sought to be achieved. There is no general or vested right to compassionate appointment. Compassionate appointment can be claimed only where a scheme or rule provided for such appointment, where such a provision is made in an administrative scheme or statutory rules. Compassionate appointment must fall strictly within the scheme or, as the case may be, the rules. The object and purpose of providing compassionate appointment is to enable the dependents members of the family of a deceased employee to tide over the immediate financial crisis caused by the death of the bread earner. In determining as to whether the family is in financial crisis, all relevant aspects must be borne in mind, including the income of the family, its liabilities, the terminal benefits received by the family, the age, dependency, and marital status of its member, together with the income from any other source of employment. Where a long lapse of time has occurred since the date of the death of the deceased employee, the sense of immediacy for seeking compassionate appointment would cease to exist, and this would be relevant circumstances which must weigh with the authorities in determining as to whether a case for the grant of compassionate appointment has been made out. Rule 5 mandates that ordinary an application for compassionate appointment must be made within 5 years of the date of the death of the deceased employee. The power conferred by the first proviso is a direction to relax the period in a case of undue hardship for dealing with the case in a just and equitable manner. The burden lies on the applicant where there is a delay in making an application within the period of 5 years to establish a case on the basis of reasons and a justification supported by documentary and other evidences. It is for the state, after considering all the facts, to make an appropriate decision. The power to relax is in the nature of an exception and is conditioned by the existence of objective considerations to the satisfaction of the government. Provision for the grant of compassionate appointment do not constitute a reservation of a post in favor of a member of the family of the deceased employee. Hence, there is no general right which can be asserted to the effect that a member of the family who was a minor at the time of the death would be entitled to claim compassionate appointment upon attaining majority. Where the rules provide for a period of time within which an application has to be made, the operation of the rule is not suspended during the minority of a member of family. Now, in another case, that is by Honorable Supreme Court in Ganesh Shankar Shukla versus State of UP and other, that is special leave petition number 3528 of 2022, decided on 15/7/2022. In para number 3rd, the Supreme Court quoted that In fact, both the children of Geeta Devi continued to be minor even after 5 years. Therefore, the rigor of Rule 5 cannot be extended in the case of the present appellant who was minor at the time of the death of his mother, the father having died earlier. In these circumstances, even when the appellant had survived on account of the financial support of maternal grandparents, the respondent is not justified in raising a technical plea of delay in seeking appointment on compassionate ground in fact of the present appeal. Some of the judgments have been referred by the learned counsel for the respondent state, but it is the fact of each case which are relevant. The facts of the present case shows total inhuman approach in dealing with two minor children of deceased. The delay was on account of the fact they had no money except the bare survival provided for by the grandparents. So, by these cases, we can say that compassionate appointment is based on the financial conditions of the family and the application which has been moved within 5 years. So hope friend you like this video about the compassionate appointment. I tried to conclude the relevant judgment in this video. So friend, thank you for watching my video. Kindly like, share, subscribe and comment. Thank you for watching my video.